Okay. Okay. Thank you once again, Prem sir. This is a really very out of the way effort that you keep taking. We know you do that day in, day out, and you are taking so much efforts for uh, having conversations with people who are appearing for the patent agent exam. And I really want to congratulate you for this. This is a very unique situation where we are seeing the next patent agent exam being held, where there is a major change in the legislation, and this legislation is explicitly important because it it pertains to the appeal proceedings. If people might be aware, whenever there is a process, we have a set of bureaucratic office which performs the basic day-to-day work. In this case, it is the patent office. If there is any decision that comes out of that particular the government office, that has to go to an appeal. This appeal is generally the one which goes to a specific tribunal. Uh, Generally used to go, but nowadays most of the tribunals have been wound up, and these have been done with a motive of reducing pendency of cases, expediting the the pending cases of appeal. And what has been done is this: the decisions given by a government office, let us keep it simple, let us say the patent office, the decisions that have been given by the patent office earlier used to be appealed at the uh, Intellectual Property Appellate Board, IPAB. Some of these decisions could directly go to the high courts, or for that matter, district court for the infringement matters. Let us not get confused over this. But let us consider only the appeal of the decision of the controller coming out of the patent office. So the decisions that were given from the controller of the patent office are were used to be appealable at IPAB, and after a decision was given from the IPAB, next appeal sequence resided with high courts and Supreme Courts. Earlier, there have been instances where forum shopping used to be done, where people used to selectively file an appeal at IPAB or at high courts. Sometimes the forums where the appeals were filed, they were generally done at multiple offices, and this was a issue. And there is an interesting case law which people can keep in mind. It is Alois Wobben case law. I will share the link with Prem sir later on, the case law, and you guys can have a look at it. It is, I think it's Alois Wobben versus Union of India. It's a very important Supreme Court judgment which clarifies how appeal proceeding have to be done. I think the name is Dr. Alois Wobben and others versus Yogesh Mehra. I think it's a 2014 judgment which which clarified what is the actual sequence of appeals and how these appeal sequences have to be done for specific uh, instances. However, what has happened is right now the major component, that is the IPAB, has been abolished. How effectively does this affect our day-to-day understanding of the patent law, and what sections have to be seen with respect to the legislation that has led to abolition of the IPAB is something that we are going to discuss here. The reason we are discussing this is that there is no separate Patent Act related gazette notification that has been brought out as of date. However, we have something with us, that is the Tribunals Reforms Act 2021, came, which was passed by the Parliament, and it has a history where there was an ordinance made. Then there was a proper bill that was moved through the Rajya Sabha, Lok Sabha, which got assent from the president, and thankfully nothing has changed with regards to the effectiveness of the act, because it is still enforceable from the date on which the original ordinance uh, was made by the central government. That is, it is effective from 4th April 2021. This act, that is the Tribunals Reforms Act 2021, is the one which is on the display, and the section 1 clarifies that it is in effect since 4th April 2021. So what is going to be a major change with regards to Patent Act if we come down to the below sections? Let me specify. It is going to be, just a moment. Okay, so if you see the act, it has specific chapters, and those chapters provide the amendments to the various acts. So chapter 3 will be for Industrial Disputes Act, chapter 4 will be for Cinematographers Act, then chapter 5 for Copyright, chapter 6 for Income Tax Act, chapter 8 is for the amendments to the Patent Act. So this is on page, it's already on display, it's on page 7. Now we are going to have a very careful look at what actually the amendments are. The first amendment that is done is to the definitions in the Patent Act, that is section 2(1)(a). The Appellate Board's definition is removed, so we don't have the Appellate Board. The clause A, section 2, subsection 1, clause A is deleted. Then we have clause U, that is clause U B, in relation to the proceedings before Appellate Board. This Appellate Board, wherever it is occurring, essentially the clause U subclause B is omitted. Then we move to section 52, which effectively also establishes that wherever you will see that in this amendment to the Patent Act, wherever the Appellate Board is mentioned, this Appellate Board term is removed. The easier way to understand the repercussion of this act is this: if Appellate Board is the first forum for appeal, this first forum of appeal is now removed. If it is mentioned as Appellate Board or something else, then only the mere reference of Appellate Board or is removed. And if it is something to do where only the Appellate Board was mentioned, it is substituted with High Court. So if you see, we will be going into detail of these things, but the general crux of idea is this. Original sequence of appeal were decisions of the controller, appeal at the IPAB, Appellate Board, then appeal at the High Court, then appeal at the Supreme Court. So what earlier happened was that whenever something with regards to an appeal of a controller's decision was mentioned in the Patent Act, it said that the appeal would be at the Appellate Board. Now this appeal to the Appellate Board will be substituted with appeal to the High Court. We will go through them in section to section. With section 52, as mentioned, the word Appellate Board or is removed because it is mentioned as Appellate Board or court. I hope readers would be able to access the Patent Act, and they can, the time we are discussing the amendments in the Tribunals Reforms Act, kindly keep referring to the specific section to which the reference is being made right now. So right now, I am referring to section 52 of the Patent Act, where it mentions that wherein a petition of revocation, the appellate board or court instead of revoking the patent. So wherever the terms appellate board or a court is mentioned, the term appellate board or is removed. Then we move to section 58, where we are talking about the amendments of the application and specifications. The entirety of section 58 in the Patent Act has been affected because the section 58 has the title amendment of specification before appellate board or high court. Now it would read amendment of the specification before high court alone, and whatever the proceedings is mentioned, it will be only pertaining to the proceedings before the high court. In section 59, it will be the same thing. The term appellate board is removed. Section 64, again, the revocation proceeding, the mentioning of anything done by an order or by the virtue of a proceeding before the appellate board is omitted. So it will only pertain to suit of infringement of a patent by the high court, or so it will read in that way without the provision of a proceeding before the appellate board. Then we come to section 71. Section 71 is regarding the rectification of a register by appellate board, and the entirety of section 71 gets affected because here now the reference will be rectification of the register by the high court. So earlier, whenever a rectification of the register was supposed to be done, appellate board used to be the first forum where a person aggrieved would be able to request for a change, and now these changes effectively have to be requested before the high court, and that is a major change because rectification of the register is something not that frequently done, but it's a major change with regards to the patent register. So section 71 is going to have appellate board replaced with high court. Kindly have a look at these changes and ensure that you read the Patent Act with regards and taking into consideration whatever the amendments are made under the Tribunals Reforms Act before the major appellate board where the appeal proceeding were done, or for that matters the rectification of the register, this process under section 71, when these were done by the appellate boards, are now changed, and these proceedings directly go to the higher forum, that is the high court. Now we come to section 76, that is again, which it's regard to the office and employees not to furnish information. Here again, the reference will change to high court. Then let us go to more. Let's go to section 113. Okay, before going to section 113, if anybody wants to raise any questions, kindly feel free to ask.
In section 76, appellate board will be removed or will be replaced by high court. Hello. Hello.
Yes, we can hear you. Yeah.
Yes, yes. So I was asking that in section
Sorry, I
70.
was on mute. Sorry, I was on mute. I was trying to answer it. Can you hear me now?
Yes, yes.
Yeah. So yeah, section 76, the word appellate board shall be omitted. So
Yes.
here it will just be under direction in writing by the central government or the controller or by order of the court. You can have a very simple logical understanding here. If the appellate board, if at all it is mentioned in the Patent Act, and it is the sole uh, body providing a particular resolution, that section or that provision in the Patent Act, it will have replacement of the appellate board by the term High Court. Okay. But wherever there are any provisions where appellate board is mentioned as an optional forum, which can provide some direction, which can be approached for some resolution, that term is only omitted. Does this help understanding how this Tribunals Reform Act is going to affect the Patent Act?
Yes.
In general?
Yes.
Yes, Samal. And I can add one, just to clarify on the question. Means appellate board should be removed by High Court, this word. So this is not required here because the word court is already mentioned out here.
Yes, sir. Yes, sir.
So there is no need to say substitute appellate by High Court because the court is already there.
Yes.
And Samath, one thing that you can clarify more. What is the difference between section 71, rectification of register by High Court now, and power of controller to correct clerical errors under section 78?
Okay, these two are okay, it's a good question. See, when you see section 71, section 71 comes under chapter 8, that is the general register of the patent. So the provisions under section chapter 8, that is from section 67 till 72, those pertain to register of patent. So when we talk of register of patent, we are talking of all the bibliographic information, the data associate, the information or that is associated with a particular patent application, the entirety of the patent application and its content. Now, any changes that have to be done once a patent is granted, the it is reflected in the register of the patent. If any changes have to be done in the actual record of this granted patent, it will be covered under the register of patents. However, when we see chapter this is chapter 13 is, sorry, I referred it wrongly. It is chapter 13, that is register of patent, and then chapter 15, that is powers of the controller generally. Now the powers of controller generally is a wide ambit which covers many different things for which the controller has necessary legal backing, and those are mentioned under the powers of the controller. However, it is also an overlapping instance that if any changes have to be done, those changes were affected by some of the proceedings that are done in front of the patent office. If there is any change in the register of the patent and those proceedings happen before the patent office, those will come under the powers of the controller there. However, general power of controller is quite a wide uh, ambit, and that we need not confuse by comparing section 71 with 78.
Thank you, Samarth.
Was it more confusing?
No, it was very clear. I mean, So I just wanted to have your views on this, because in previous one of the classes, somebody asked this question to me, and therefore I wanted to have again discussed so that it is more clear to them. So 71 is just referring to rectification of the register only, the details in the register, but 78 is regard to the any change in the application, any change in the complete specification, correction over there, everything can be done. In register, entry goes only for the name, address, place of work, place of business, any person showing interest, any assignment, licensee, license out, all those things are there in the register. So if there is any change required there, so that is what comes under section 71, rectification register by High Court. And this 78 is power of controller to correct clerical errors. So these are coming. So
yes, and what will be more pertinent is to remember that whenever we are referring to the amendments to the specification, that is the which are quite important, that is section 757 and 59. We are digressing from the actual Tribunals Reforms Act discussion, but let me just since we are discussing 78, let me just highlight, let me just focus on the fact that these corrections under 78, these are with regards to correcting the clerical errors and other things which are described in detail in 78. If you want, we can just take up the section 78 in detail after we do the Tribunals Reforms Act discussion. That will that be helpful?
We've covered some of 78.
You covered it. Okay.
Yes, in detail.
Okay.
So just with regard to question, we wanted to just understand it. So we can continue with this Tribunal Reform Act now.
Okay. All right. Any other question? Meanwhile. If not, then we proceed to section, the changes that will affect section 113. Now in section 113 is certificate of validity of specification and costs of the subsequent suits for infringement thereof. Here we have section 113, subsection 1, words appellate board or wherever occur, they will be omitted. So this is pretty straightforward because here appellate board is mentioned as an optional authority to the High Court. Then for A, subclause A is done. Subclause B is the words as the case may be shall be omitted. Okay. In okay.
So this is on the second line. If you read, if in any proceedings before appellate board or a high court as for the revocation of the patent under section 64 and section 104 as the case may be. So
yes,
that is the word as the case may be, that is
as
removed.
the case may be, this will be removed. The thing is, because it is referring to the possibility of two different proceedings appearing before the appellate board or the High Court, there were two different situations, possibilities, and now we will have just one specific track of proceedings before the High Court. So there is no possibility of two different cases. So there is no as the case may be. It will be direct reference to the chronology of things happening before the High Court. So that is for clarification on section 113 subsection 1. Then subsection 2, sorry, in subsection 3, the word appellate board is again removed. That is again pretty straightforward. Okay, now we have an entire chapter to talk about. That is chapter 19, appeals to the appellate board, which is a big chapter where the entire proceeding of how what will be the appellate board, what are the technical members, what is the staff of the appellate board, how are the proceedings before the appellate board, what is the power of the appellate board, Now this chapter, if you see, it is from chapter 116 to chapter 117H. Now it refers to many proceedings which happened before the appellate board. It provided the constituents of what is the staffing and things. This is the major chapter which is affected, and you can see section 116, 117 entirely are being omitted. That is, these sections will no longer be uh, present. Section 117A, which talks of the appeals to the appellate board. Now the word appeals to the appellate board, the term will now read, that is section 117A, will read appeals to High Court. By far, this is the most important section in this chapter 19, which is changing. I think the entire chapter is majorly affected by Tribunals Reforms Act. So the chapter itself will read appeals to the appeals to the High Court. Sorry, it says appeals. The chapter heading says only appeals. I'm sorry to say, it is already mentioned there in the Tribunals Reforms Act. The chapter will read appeals. Section 117A will read appeals to the appellate board. I'm sorry, just a moment. Yeah, sorry. So when we see chapter 117A, the appellate board is now being substituted to High Court. What this essentially means, wherever there is a provision for appealing a decision or order or direction of a controller or central government under various sections, this you can see, these decisions, orders, or directions issued by central government or by the controller, these will now stand for appeal before the High Court. What are these sections? This is mentioned in 117A, subsection 2, that is the orders given under, just a moment, sorry for that. These are section 15, 16, 17, 18, 19, 20, subsection 4, subsection 4 of 25, section 28, 51, 54, 57, 60, 61. So these list out all the these list out all the scenarios where decision, order or direction is made by the central government or the controller. It will pertain to the grant of patent, pre-grant oppositions, post-grant oppositions, and yeah, so on and so forth. These are the all major changes that are whatever decisions are given were earlier appealable to the appellate board. Now they will be appealable to the High Court directly.
Yes,
now there is the sorry.
No, I will just add here for understanding. Section 117A, it is appeals to High Court now, and
Yes.
therefore 117A2, there are list of some sections. Okay.
Yes.
In
Yes,
all
yes,
these
yes.
sections, any decision given by the controller or the central government, if you are not happy with their decisions, we can now go to High Court directly now. And in exams, the question is asked like this: they will give these are the sections for which and decision of central government or controller can be appealed to High Court. So they they give some sections name, and there are some wrong answers, there are correct answers. Therefore, just to memorize this section number would be beneficial for exams. And because this is a recent change, there will definitely be questions based on this. And we just have to remember that if any question comes where it says the name appellate board, that is wrong. I mean, it will depend on how the question is being asked. but we need to be very cautious with the name Appellate Board, that everywhere Appellate Board was there, it is now removed, and that is High Court. So they are not going to ask which sections are omitted, but the question will be based on what changes are affected by this Tribunal Reform Act. So that is a way. And please keep marking in your books wherever these are coming up, so that we don't get confused. So in general, the idea is Appellate Board is removed and a High Court is retained. Thank you so much.
Yeah, that is the crux of why we are having this conversation. Like, these are going to affect and will reflect in the MCQs. They might have some detailed questionnaire in paper B. So yeah, MCQs, as Prem sir mentioned, they might provide a list of sections which where the appeals of directions or orders given by a particular authority, say central government or the court, whether it will be appealable to which forum. And they might trick you to say that that one of the option they might include Appellate Board as one of the forum where appeal can be done. These questions, I don't know whether they will be interested to make it more trickier. You might see some questions where previous appeal pending at IPAB, whether those are also discussed. I don't think they will make it this much complicated, because even as of date, the transition of pending cases from Appellate Board to High Courts is ongoing, and it will be too much to add up to the complexity of things. But it is always good if you guys can have some clarity on this. Feel free to ask questions on this. We can take it up once we cover all the sections of the Tribunals Reforms Act. We will touch that part. What is the status, or how do we read the pending cases before IPAB? We will take it if time permits also. So coming back to section 117A, it will read to appeals to High Court. So section 116, 117 are omitted. Section 117B, C, D, 117B, 117C, 117D, these are deleted. It's omitted. 117E, word Appellate Board is substituted with High Court. Now, this is a main change. We are referring to clause M of this, and the Appellate Board was the only forum where the proceedings were supposed to move forward. Now, it will be before the High Court, so it's substituted over here. So 117A remains with major changes. 117E remains with major changes. So in both cases, wherever Appellate Board is mentioned, it is substituted with High Court.
I just have one query.
Yeah,
as you
sure.
mentioned, this section 117B, C and D, this is shall be omitted. So it means that the complete sections has been omitted?
Yes. You see, the thing is, IPAB is abolished. Now, there is no point having a section which talks of what is IPAB, what is the staff of IPAB, or what is the power and procedures or the bar of jurisdiction of court. These things have no meaning because the forum itself is abolished, right?
Okay. Thank you.
When we see the changes with regards to Patent Act by abolition of IPAB, is that how will the procedure keep on in absence of IPAB? That is the focus that we have to keep. As in earlier, okay, there was a procedure which was taken up before the IPAB. Now that the IPAB is abolished, we can't say that appeals will not be filed. Appeals will be filed, but what will be the procedure? And of course, the next forum is going to be the High Court. And whenever these changes have to be done, it will be referring to the appeals to High Court, or whatever the procedural changes have to be done, it will be referred in consonance or with regards to the High Court. So that is the essence of the discussion that we're having in today's session, that although IPAB is removed, appeals are still something that the applicant or the patentee, or for matters any other person interested, they will have to file at some forum, and that forum essentially will be high courts. Okay, so 117A is important, 117E is important with major changes. Then we have 117F, 117G, 117H. These are also permitted. Okay, this is an important section. If you guys have any concerns, some confusions, please feel free to ask before we move to section 151.
So essentially what it means that in future, if we are going to purchase a new book on the Patents Act, these sections which have been written omitted will not be there, will not be printed again. So recent one that I have, they have printed this, but maybe after this, what we get, this will not be printed. So we don't have to bother about all those sections which are omitted. We can simply extract them out from our book, and we don't have to study them anymore.
Yeah, Frames are looking at things with the silver linings.
Yes,
Okay.
my focus is for the exams only. So
yes.
once
Yeah,
they
you're
qualify,
correct. You're correct.
they can do many things, but for exams, they are not required. So less burden on our memory capacity.
Great. Any question? I think there is just last one section which is also affected. That is section 151, transmission of orders of court to controller. And so it is with regards to wherever there is any order given by high courts or appellate board on a petition of revocation, these including order granting certificates. Now here, if you see, it is an order of high court or appellate board. Now appellate board is gone, so it will only read as order of high court. That should be it. So only the appellate board was mentioned as an option to the high court, so it is removed. And that is subsection 1, subsection 3, appellate board or courts, as the case may be, will now read as courts. So that is provisions of subsection 1 and 2 shall also apply to the court which appeals were preferred against the decisions. Okay, so here it will only be courts because the term appellate board or is removed. So these should be pretty straightforward now. Okay, we are done with the amendments that will affect Patent Act. So just summing it up, we are required to have understanding that there is Tribunals Reforms Act 2021, which is in force effectively from 4th April 2021. So it is on effect from 4th April 2021. This act has been notified on 13th August 2021. The reason it is effective since 4th April 2021 is that there was an ordinance passed in the same effect, abolishing the tribunals, including the IPAB. It is enacted by a proper bill passing and in form of act with president's assent, and that process has been completed by gazetted notification on 13th August 2021. And in this Tribunals Reforms Act, we are concerned with Chapter 8, that is Amendments to Patent 1970. And in this chapter, amendments to the Patent Act are listed. So these include the changes in the definition of the appellate board, and the instances where appellate board was a forum to provide a redressal, or was the first forum to provide a redressal. These are now substituted with the term high court in most of the cases, or in general courts in other instances. So kindly, those people who are planning to appear for the patent agent exam, you guys can keep it in mind that since this is a very recent change in the patent affecting the Patent Act, you guys need to be aware of it. You guys can actually score good marks uh, because of based on these changes. So it's easier, and the sections are already listed out in this Tribunals Reforms Act, which are going to change. Any questions, please feel free to ask.
Yes, I have a question. What is the difference between these dates, like 4th April 2021 and 13th August 2021? How a question may be asked on these dates?
Okay, so these dates, you just have to remember that if there was any, okay, this is actually easier to answer from the perspective of how, till what time was IPAB actually functional. So effectively, IPAB was functional only till 4th April 2021. IPAB is abolished since 4th April 2021. So what does this mean? This means that there were appeals or there were redressals sought from IPAB only before 4th April 2021, and after 4th April 2021, IPAB doesn't exist.
Okay.
Yeah. So to add to this, so I think that question would be like this. Question would say that Tribunal Reform Act 2021, which affected the appellate board existence, came into force on option A, 13th August 2021, option B, 4th April 2021, and option C and D, other things. So your answer will be 4th April 2020. So this is the question you may get, because there are two dates, 13th August 2021 and 4th April 2021. So
Yes,
many
sir.
times this kind of question comes with regard to enactment. And so this is the one question that can come. They will give some dates, and your answer should be 4th April 2021. Don't get confused with 4th and 13th, because 13th, it was published in the official gazette, but it says it came into force on 4th April. So this is one question you may get with regard to dates.
Okay, thank you, sir.
Any other questions? If there's no more questions, then we would stop discussion on Tribunal Reform Act now, and we'll proceed with discussion on other sections as we are doing.